Good morning, everyone. We're going to get started again, and right now our next session is going to be Hot Topics in Labor and Employment Law. Tom Revnew of Peters, Revnew, Kappenman, and Anderson will be our speaker. Tom represents, in connection with the full range of employment and labor law issues. He successfully litigated a wide variety of labor and employment law claims before state and federal courts and administrative agencies, including claims involving non-competition and confidentiality agreements, trade secrets, discrimination, harassment, retaliation, wrongful discharge, prevailing wages, wage disputes, workers' compensation, OSHA, the National Labor Relations Act, and workers' compensation. He has spoken for us many times. We are so happy to have him back, and go right ahead, Tom.
All right, very good. Thank you, Chris. Hopefully this, everybody can now see my PowerPoint slide on your screen. Chris, and if you can't see it, please let me know, but I believe that you're now looking at the PowerPoint.
I can see it.
Perfect, thank you. So a lot obviously has happened in 2020, a lot of it COVID related, a lot related to the Family First Coronavirus Response Act, and obviously quite a few other things have taken place in the last nine and a half months. And of course, now we have a Supreme Court vacancy, which is going to lead to additional issues with regard to what's going to happen in the next 6 weeks or thereafter. And I'm not going to get into the Supreme Court vacancy today, other than to say, obviously, that will impact what happens from a labor and employment law perspective. Whoever is appointed and later confirmed by the U.S. Senate would have a significant impact on labor and employment law. But today I'm going to focus on a number of items, some which it's not going to be much of a surprise to you. The Family First Act, some frequently asked questions. Top return to work items. The good news is that we are seeing more and more employers resuming work, going back to work. And of course, going back to work means that there's a lot of different things that you need to consider or should consider with regard to your hiring practices, whether you have your safety protocols in place, whether you're complying with wage and hour laws to the extent that you have employees that have been telecommuting. And I'll discuss a few other items in this very short segment. I have a little less than an hour to talk about changes in the law, and frankly, there have been more changes in the law this year than at any point in my career. And like many of you, when COVID hit and things were shut down, a lot of us were scrambling to understand what our obligations were as employers, but also understand some of the new laws that were coming into existence. And it's pretty incredible how quickly some of these laws came into existence and how quickly guidance was issued by the Department of Labor to hopefully avoid some of the ambiguities. But the first item I wanted to talk about was the Family First Act, and a couple things to think through or to be aware of is who's a covered employer. And with regard to covered employers, most of you on this call probably are covered employers, and that means that if you employ fewer than 500 full-time and part-time employees within the United States, you are a covered employer. And when you get to the counting, you count not only employees on leave, but temporary employees, as well as day laborers. Independent contractors do not count towards the 500 employee total. If you have more than 500 employees, you don't fall under the Family First Coronavirus Response Act. And for some of you who are not familiar with the Family First Coronavirus Act, that's essentially the law that came into existence in April, which essentially said that you have to pay employees 2 weeks of sick pay if they have a qualifying event related to COVID, i.e. They contracted COVID, they're helping somebody out with COVID, they've been ordered by the the health department or a doctor to self-isolate. Those are some of the instances where they're entitled to the 2 weeks of sick pay. And then of course, employees are also entitled to up to 12 weeks of emergency family medical leave as a result of needing to care for a child and not being able to return to work because of the care for the child, i.e. school is closed or distance learning is taking place and the parent needs to stay home with the child because there's no one else at home to care for the child. So that, in a nutshell, is the Family First Corona Response Act. There is an exception. If you have fewer than 50 employees, you are not necessarily covered by the Family First Coronavirus Response Act. You would, in essence, have to certify that you have fewer than 50 employees and also certify that providing leave would result in your business expenses and financial obligations exceeding the available business revenues, or the absence of the employee requesting paid sick leave or the emergency family medical leave would entail a substantial risk to the financial health or operation of the business, or there are an insufficient number of workers who are willing, able, and qualified to work, and you need them at the business to operate at a minimum capacity. Bottom line is, I'm not aware of any clients that have certified that they have less than 50 and have tried to avoid the obligations on the Family First Coronavirus Response Act, predominantly because there's significant concerns that if you're not paying either the paid sick or the emergency family medical leave, that you're going to walk yourself into a lawsuit by a plaintiff's lawyer who will take the position that you don't meet these exceptions and therefore you should have paid. If you violate the Family First Coronavirus Response Act, it's essentially like violating any wage and hour case, which in essence means that you're on the hook for attorney fees and costs if the employer were successful in bringing a case against you. And so as a result, most employers that have fewer than 50 are complying with the law just because they don't want to have the potential liability. And of course, they also realize that they're going to get the rebates or the tax refund from the government when they file their quarterly taxes. A lot of you probably heard about a case that was taking place in the District of New York, where essentially on August 30, federal court in New York ruled that 4 parts of the Family First Coronavirus Response Act's final rules were invalid. Essentially what the district court in New York ruled is that when the Department of Labor issued its rules, they didn't do a good job of explaining the rationale behind their rules, and therefore they were invalid. And so the federal court in New York invalidated 4 different components of the rules. The one, that the requirement that leave under the Family First Coronavirus Act is only available if an employer has work available for the employee. 2, the district court struck down the requirement that an employee must have the employer's consent to take leave intermittently. 3rd, the court struck down the definition of an employee who is a healthcare provider. And 4, the court struck down the requirement that the employees must provide their employers with certain notices and documentation before taking leave. And so that decision came down on August 3rd. You may have been paying close attention, and if you haven't, the Department of Labor issued revised guidance, revised rules in response to the court's decision. And in essence, the good news is for employers, the Department of Labor read the court's decision as essentially saying, well, you just want us to provide clarification or the rationale behind why we had the rules that we had. And therefore, we're essentially going to reconfirm that the rules are what they were when they were issued in April, but just provide more rationale as to why the rules were drafted the way they were. So in essence, the Department of Labor confirmed that an employer must have work available for an employee to qualify for Family First leave for any reason. essentially what they're trying to make it very clear is that an employee will be eligible for the Family First benefits if they're unable to work because of a COVID qualifying event. If they're not able to work because of a decline in work or a shutdown of the business, they're not going to be eligible for the benefits under the Family First. Second, the Department of Labor reconfirmed that an employer must consent to an employee taking leave intermittently. And essentially, when the Department of Labor issued its revised rules, it essentially discusses the balance between the employee's need for leave with the employer's need to avoid disruption to its business, and then went on to further explain that employer consent is necessary because it's a condition of teleworking, and employers must consent to allowing employees to telecommute intermittently in order for the employee to be eligible for intermittent leave under the Family First. Additionally, there was a little bit of guidance with regard to school closings, and I'm assuming that some of you in the audience today, you have children that are going to school under the hybrid model. And the hybrid model is essentially that the students are in school, in session, in person on certain days of the week, and then they're at home attending school virtually on other days of the week. And what the Department of Labor did with the amended rules is they essentially said that the employer consent requirement does not apply when an employee needs leave because the child attends school on an in-person or alternate day schedule. In other words, each school day closure constitutes a new reason for leave. When school reopens, the need for leave ends. And when it closes again, the employee may start a new leave period. So in other words, when the students are in school in person, there's not a leave requirement. When they are attending virtually, the leave resumes, and you may or may not permit the telecommuting during the time that the students are attending class virtually. With regard to the documentation requirements, the new rule clarifies that employees do not need to provide notice in advance or as a prerequisite to paid sick leave entitlement, which makes sense. The employee's not going to necessarily know right away that they have COVID or that they need to seek treatment. But if they're going to take emergency family medical leave, which is a portion where they're caring for their son or daughter, they must provide notice of the need for leave as soon as practical, which is going to be dependent upon the facts and circumstances. In a nutshell, my view of the amended rules that were issued a couple weeks ago should not change much of the way that you operate. That in essence, the rules that were issued in April are very similar to the rules that were amended in September. So I think everybody's going to be fine following the April rules with a few nuances that shouldn't impact much. And of course, since April, since the government shutdowns, we've seen as attorneys more and more employers going back to work. And of course, going back to work raises a whole host of return to work items and things that you should be thinking about as employers. And some of them relate to your hiring practices. And things that we're recommending that our clients think about is when you return your employees to work, or you're attempting to return them to work, that you should be communicating with them and communicating with them in writing. And of course, when there was a $600 subsidy through unemployment a lot of our clients were having significant difficulty in getting their employees to return to work. Obviously, that subsidy has essentially disappeared, but it is still a good practice to consider providing written return to work notices to your employees to avoid disputes with regard to potential unemployment claims. And so we're recommending to our clients that they include in written notices to the employees the date of the return, any new policies that you may have, changes to terms and conditions of employment, obviously, especially as it relates to pay or their hours of work. Certainly to the extent that the employee is an at-will employee, confirm that they're being returned on an at-will employment basis. Certainly you should detail your new safety measures that have been implemented, which I'll talk about very briefly later on. And then finally, a reminder to employees that if they're sick, they should stay home. Now, when you're rehiring or you're hiring new employees, you know, things to think about relate to the Form W-4, and particularly the Minnesota Form W-4MN. And things to remember is that with the changes to state and federal law, Minnesota employers now need to have their employees complete both a federal Form W-4 and a Minnesota Form W-4 for new employees, because the federal form does not necessarily calculate the allowances for Minnesota withholding taxes, and failure to have the employee complete the Minnesota form may result in improper withholdings. Additionally, the Minnesota form should also be used because if an employee requests to claim fewer withholding allowances than prior years, when you're rehiring employees, they may need to fill out both the new forms, both the W-4 and the W-4MN. And of course, if you're bringing employees back to work, you should clearly be thinking about the Minnesota Wage Theft Prevention Act. And as many of you may recall, this was a law that came into existence in 2019. And under that law, it requires that the employer provide new employees with written notice containing specific information about wage rates and paid time off. And you need to keep a copy of that notice in the employee's file. That notice must contain a statement that the employee can request the information in their native language. Rehired employees should be provided a new form, and employees returning from leave with changes to their terms of employment. So if you're bringing in employees back with a new rate of pay or the paid time off policy has changed, you need to provide them with written notices of the changes to those benefits. I know some of you in the audience also have operations within Minneapolis, and keep in mind that Minneapolis has its own wage theft ordinance that has stricter guidelines than state law. And so under the Minnesota wage theft ordinance, you have to list the amount of sick and safe time accrued and unused by the employee. That's got to be included in every earning statement. And any changes to an employee's form must also be signed by the employee. So keep in mind, under state law, if you change benefits, if they've already signed off on the form, you just have to give them written notice. In Minneapolis, if you change anything that was on that form, they have to sign acknowledging notice of the changes. Also keep in mind that when you're returning workers, there may be certain things that you need to be compliant with regard to your employee benefit plans. And so we're just recommending that you review your plan documents to determine whether returning employees are required to satisfy the waiting period to enroll or re-enroll in the benefit plan. Some plans have a provision that employees rehired within a certain time frame do not have to satisfy the waiting period before re-enrolling in the plan. So check on that. And if a furloughed employee was kept on the plan as a non-COBRA participant, obviously no action is needed as they continued as a participant. Some questions are being raised is, what do we do if employees want to stay at home? Certainly if employees want to stay at home, you should consider keeping employees at home if they've been teleworking and they've been maintaining productivity. Some may have ongoing health concerns or they have childcare issues that support this decision. But additionally, make sure that you stay cognizant of anything under the Americans with Disabilities Act, where you may have individuals who have a disability that are unable now to return to work, and allowing them to telework may actually be considered a reasonable accommodation because we've been allowing it to take place for the last 6 months. And then another thing to keep in mind is what is the Equal Employment Opportunity Commission saying as it relates to providing employees with leave. And essentially what the EEOC is saying is that as long as employers are not treating employees differently based upon a protected characteristic, the employer may provide flexibility to employees who are caregivers to school-aged children. But be careful that when you're providing those accommodations, that you're not just providing the accommodations to female caregivers, or you're providing female caregivers with more flexibility as compared to a male caregiver, because if you do, you could walk yourself into a discrimination type claim. So a lot on COVID returning to work. Other things, as the economy hopefully is starting to gear back up, keep in mind that there was a new I-9 form that was issued that became effective as of May 1st, 2020. So as of May 1st, 2020, you should be using the new I-9 form. If you're using an old I-9 form, you are violating the law, and that can lead to significant penalties. And I'll talk a little bit about that momentarily. But the new form, to make sure that you are using it, make sure you look, it has a October 21st, 2019 edition date. The revised form lists additional countries in the country of issuance field in section 1. It clarifies that an employer may designate anyone to be the authorized representative to complete section 2, but the employer is still liable for any violations. In the identity document column, you no longer have to write not applicable. And then finally, the new form clarifies that a worker's employment authorization document that contains a photograph is considered a List A document when you're filling out the form. So what have we seen with the I-9 audits? We've essentially seen a significant increase in audits. If you look at 2017, there were 1,360 Homeland Security audits that took place in that year. And if you look forward to 2019, you can see that that number has significantly increased to almost 6,500 audits. Right now in our office, I think we have 4 clients that are going through an I-9 audit. You can see that the penalties and the fines issued against employers last year in 2019 were well over $14 million. I have seen fines issued in the Twin Cities as high as $550,000, and that was a client or an employer, I should say, that had roughly 2,500 employees. And if you recall, with regard to I-9 compliance, the fines are based on a per violation basis and they're not capped. And so for this particular employer with 2,500 employees, they had multiple mistakes on a single I-9 form that led to multiple fines being issued per I-9. So just some basics with regard to I-9 completion. First day of employment, obviously the employee must complete section 1. The employer may have the employee complete it before the first day, but only after the job has been offered and accepted. And then of course, your obligations as the employer is to complete that document by the 3rd day. We recommend that you do not abbreviate for consistency, that you use full words, avenue, instead of av with a period. You want to verify that the employee filled out section 1. Their errors on section 1 are your responsibility. So if an employee incorrectly fills out section 1 or fails to fill out all of section 1, that can lead to you having some penalties of Homeland Security issues, fines. If you rehire employees within a 3-year period of time from the date that you had them, or from when they completed their Form I-9, you may either use that form or they can complete a new one. If they're still authorized to work in the U.S., they do not need to provide any additional documents. However, if their I-9 form has expired, you must enter the employee's full name on the original Form I-9 form at the top of section 3, enter in any name changes in block A, enter the rehire date in block B, re-verify their employment authorization in block C, and enter your name and sign and date in section 3. Keeping in mind that if the employee's previous form is an old version of the form, you must complete section 3 on the current Form I-9. One thing that we spend a lot of time talking to clients about, and I'm not going to spend a lot of time today just in the interest of time, is that you can do a self-audit, and the self-audit that you do certainly can minimize your exposure to fines and penalties. And we've recommended to our clients that they do their self-audits, that they're prepared for an audit by Homeland Security. And so there are a lot of ways that you can undergo a self-audit. There's a lot of materials out there on how to do your own self-audit. Homeland Security has published their own booklet on how to conduct a self-audit. Clients will call us just for some guidance. If you're a member of the Society of Human Resource Managers, SHRM also has a lot of materials on how to do your self-audit. But in essence, if you discover an error based on a self-audit on a previously executed I-9, as an employee, you should draw through a line through the incorrect information, enter the correct information, initial and date the correction. If there are multiple errors, the employer may redo the section on a form, new form, and attach it to the old one. And if an entire form is required for major errors, that's okay, you can do that, but you just include a note regarding the reason you made the changes or had the use of a new form. And of course, you would staple the old form to the new form. Keeping in mind that when it's a section 1 correction, that section that the employee would complete, only the employee may correct errors in section 1. That's a lot of information in a short period of time on I-9s. As we're talking about returning to work, make sure that you've implemented safety protocols. And I'm certain that everybody in the audience has implemented the safety protocols, but just some reminders is Minnesota, we have a mask mandate, and face coverings are required in an indoor business or a public indoor space. Face coverings are required when employees are working outdoors in situations where social distancing cannot be maintained. There are certain individuals who are exempt from wearing masks. Those are individuals with a medical condition, whether it's a mental health condition or a disability that makes it unreasonable for the individual to maintain a face covering. I've had a lot of clients ask me, certainly early on in the mask mandate obligation, what do I do if an employee says that they can't wear a mask? And certainly as an employer, you can ask the employee for documentation regarding their claim of a disability. Now, I'll also note that some of you may have customers who may come into your facility. Maybe they want to do a walk through the plant or what have you. And you can't ask a customer to provide documentation with regard to their claim disability, but you can, as far as an employee, ask that they provide you with documentation to support that they can't wear a face covering. And of course, individuals, when wearing a face mask, if it's going to create a job hazard for them, of course, they don't have to wear a face mask either. Face coverings can be removed when somebody is testifying, they're speaking and performing in an indoor business or public indoor space in situations or settings such as a theater, a news conference, legal proceedings, presentations, lectures. Face shields should be considered. Certainly, face coverings can be removed when an individual is eating or drinking indoors. When an individual is alone, so when you're working in an office alone, or you're in a room or a cubicle with walls that are higher than face level and social distancing is maintained, you do not have to wear a mask in those settings as well. Make sure that you've updated your COVID-19 preparedness plans to include the face covering requirements. Also keep in mind that as an employer, you're required to post one or more signs that are visible to all persons, including workers, customers, and visitors, instructing them to wear face coverings. That's also part of the governor's executive order. I'm assuming everybody in this audience has a preparedness plan. You're required to have that preparedness plan as a critical sector business by June 29th, 2020. And then, of course, non-critical sector businesses were required to have the preparedness plan before returning to work. The state of Minnesota has provided employers with a lot of guidance with regard to what is required within a preparedness plan. I know PIM has also worked with members to make sure that they have the preparedness plan ready. So make sure that you have your plan, make sure your plan is updated to reflect the new face covering requirements. And then in addition, also keep in mind that along with the face covering requirements, there are also additional requirements for each preparedness plan, which includes some of the requirements for ensuring that you establish health screening protocols for workers at the start of each shift, documenting the sanitation schedule and checklist at your facility, and also providing employees as well as management with regard to training on COVID exposure, as well as your policies and procedures. And then, of course, we get into OSHA. And with regard to recording COVID-19 as a workplace illness on your OSHA 300 log, there's been a lot of debate with regard to whether or not it's recordable or not. And the bottom line is OSHA has tried to give employers with a lot of guidance on this particular issue. And in essence, COVID-19 can be recorded as a workplace illness if the following items are met. Number one, the case is confirmed to be a case of COVID-19. Two, the case is work-related, and that's really the big issue for employers, right? How do you determine whether or not a COVID-19 incident arose out of employment? And we'll talk a little bit about that in the next slide, but essentially, OSHA says work-relatedness is an event or exposure in the work environment either caused or contributed to the condition. Again, I'll talk about how you attempt to determine whether or not something is work-related in a moment. And then third, the case involves one or more of the general recording requirements set under the OSHA standard, which is essentially that the illness required medical treatment beyond first aid, or the employee had to take time off from work. But in order to determine whether or not a COVID case is work-related, essentially what OSHA is asking that employers do is that you investigate, or conduct an investigation into the work-relatedness, which is number one, asking the employee how they believe they contracted the virus. Two, discussing with the employee their work as well as out-of-work activities that may have led to the illness, and reviewing the employee's work environment for potential COVID-19 exposure. And of course, as part of your investigation, it has to be a reasonable good faith investigation. So you're looking at all the evidence at the time of the determination, and then looking at the evidence of whether COVID-19 was contracted at work. And essentially what OSHA says is, look, it's more likely that it was a work-related incident if the employees are working closely together and COVID-19 was contracted shortly after a lengthy close exposure to either a customer or a coworker who has a confirmed case, or when their job duties involve frequent close exposure to the general public. Conversely, if the employee is the only one to contract it and the job duties do not include frequent contact with the general public, then obviously it's less likely that it's going to be a work-related exposure. And of course, essentially what OSHA is saying is you need to do an investigation to determine work-relatedness. And if you have a significant number of employees that are coming down with COVID, chances are it's a work-related exposure. And if it is, then you have to put it down on the OSHA 300 log. And of course, if you don't record the COVID exposure or incidents on your OSHA 300 log, then you're subject to penalties for failure to record. As you return to work, or if you have employees working from home, you know, one of my big concerns with clients and employers is whether or not they're compliant with both state and federal law, and keeping in mind that any non-exempt employee who is paid by the hour must be paid for all hours that they work, and they must be paid for work for over 40 hours per week under federal law, over 48 hours under state law. But you know, when you have employees who are teleworking or they're working from home, it's really blurred the lines. And you may have employees that are working through a alert lunch where maybe they were more closely monitored while they were working in the office. And of course, if they're working through their meals, that's compensable time. And of course, you may not know that they're working through their time. And so a good practice is to make sure that they're documenting the hours that they worked, and they're essentially certifying that those are the hours that they worked. Additionally, I think we're going to see some issues under wage and hour laws with regard to employees may argue that they should be paid during any employer mandated health check. So they come into the office and you're checking their temperatures before they can punch the time clock. I think you're going to see employees saying that, hey, you know, that's work related. If I have to wait around for 15 minutes in line to get my temperature checked, or I need to clean personal protective equipment during a 15-minute period of time in order to work, I'm doing that for the employer's benefit, and that should be compensable time. And there was a case in California very recently involving Amazon where they had a class action wage and hour lawsuit where they essentially settled that. And they settled that case for a significant amount of liability. I'm going to tell you that every employer has different processes that they go through with these health checks, and it's something that you should think about with regard to, if you're not compensating, whether you want to compensate that just to avoid having a wage claim brought against you. With regard to time off, make sure that you review all leave and time off policies. In the COVID-19 world, certainly you're going to want to review those policies, make sure that they're compliant with current law, but also make sure that they meet what your business needs are now. Make sure that employees understand what the company policy is with regard to calling in sick, that if they're supposed to talk to a supervisor, that they talk to a supervisor, that if the rule is leaving a message is not sufficient, then making sure that they understand that. And then, of course, also keep in mind that when an employee requests time off, you really should be asking why they need to take the time off, because their need for leave may be for a leave that's protected under federal law, whether it falls under the Family Medical Leave Act, or it falls under the Emergency Paid Sick Leave or the Emergency Family Medical Leave Act. And so make sure that when employees are asking for time off, that you have an understanding of whether or not that's leave that is compensable or not. Unemployment insurance, just a quick update, perhaps more of a reminder that under Governor Walz's executive order, if you are separating an employee, you are required under the governor's order to notify separated employees that they can apply for unemployment insurance benefits. And that remains in effect until December 31st, 2020. And that includes, you need to give that notice to all employees who are laid off, they're terminated, they're furloughed, or otherwise separated from employment. Employees falling under those categories need to be notified in writing that they can apply for unemployment insurance benefits. And then the last topic that I'm talking about is just a brief regulatory updates and some things to make sure that you're compliant with. Number one, Department of Labor. July 16th, 2020, the Department of Labor issued a series of new forms that can be used by employers to document leave under the Family Medical Leave Act. Those forms are available on the internet under the Department of Labor website. You're not required to use the forms. The DOL claims that the new forms are easier to use, and I would agree with that. Employees who provided information on the old forms cannot be required to submit the information on a new form. But I'll tell you that the new forms, I think, are easier to use. And so you should take a look at the new forms and consider using them if you fall under the Family Medical Leave Act. Two, the Department of Labor also released an updated version of its model COBRA notices. Both the general notice, but it's required when the employee enrolls in the employer-sponsored medical coverage, and the election notice required after the employee has a qualifying event for COBRA, have been updated. Again, I'd recommend that you take a look at these model COBRA notices. I think they'll help you out tremendously. There are also new sections to explain how Medicare eligibility affects COBRA participants, which obviously is a hot topic for the older workers. Some may be asking, hey, what's going on with the EEO1 requirements? As you know, if you have 100 or more employees, or you're a federal contractor with certain criteria, you have to file an EEO1 form. And essentially, the Equal Employment Opportunity Commission said it would delay its annual collection of employment data until March of 21. And their reasoning was that it would ensure that the information obtained would be more accurate and reliable, since we've been faced with record unemployment. Generally, the data that's required is the race, gender, job categories of employees, and it's submitted via the form EEO1 by private sector employers. Pay data is no longer required to be collected as of 2020. Obviously, we're in a presidential election cycle. I suspect that if Vice President Biden was elected, we might be back to having to collect pay data and providing that information to the EEOC. Well, we'll see how the election goes. Minnesota updates, just real quick. Minnesota minimum wage, keep in mind that we have a minimum wage requirement under state law. Large employers, those who have $500,000 or more in gross revenue, have to pay $10 per hour. Small employers are required to pay $8.15 per hour. Keep in mind that Minneapolis and St. Paul also have their minimum wage requirements, where both cities are seeking overtime to get to $15 an hour. So as of July 1st, 2020 in Minneapolis, there are two different rates depending on the size of your business. If you had more than 100 employees, you're required to pay $13.25 per hour. Small employers, $11.75. And then St. Paul has their own minimum wage requirements as well. And essentially, they break it down to macro employers, those who have that have 10,000 employees or more. As of January 1st, 2020, the minimum wage rate was $12.50, and it'll make its way up to $15 by July 1st, 2022. And then, of course, on this slide, you can see what the minimum wage requirements are for 2020, depending on how many employees you have. And then, of course, under both Minneapolis as well as St. Paul ordinances, once an employer reaches that $15 minimum wage rate, there'll be an automatic increase announced September 1st of each year. Some folks have asked, what are the statistics with regard to discrimination cases? The last information I saw from the Minnesota Department of Human Rights was a little surprising that the number of cases thus far have been down for the last 6 months. Most common cases were disability and race, with gender following, and then age being the number 4 most frequently asked number. Federal changes have also gone down a bit. 72,000 complaints this year versus 76,000 last year. And you can see that the breakdown is very similar to Minnesota with regard to the number of claims that have been filed. You can see that with regard to the percentages given, oftentimes when employees or former employees file suit, they're claiming that they were discriminated against based upon multiple protected characteristics. As an attorney that's helped employers with a lot of layoffs, whether they're individual layoffs or group layoffs, age claims or age discrimination claim concerns have been a significant portion of our advice and guidance with employers. And you can see that the number of age claims or the percentage is still lower than other protected characteristics. And that's not a big surprise to me. Just real quick, I think everybody's aware that there was a Supreme Court decision issued in June of this year where essentially the Minnesota Supreme Court affirmed the City of Minneapolis Safe and Sick Time Ordinance and essentially said that there's no conflict between the city ordinance and state law, so the ordinance was not preempted and Minneapolis could have a safe and sick time ordinance. And the one takeaway for those in the audience is, if you have employees that are working in Minneapolis, even though your business may be based in a different municipality, if they work at least 80 hours per year in Minneapolis, they're entitled to at least 1 hour of employee safe and sick time for every 30 hours worked, up to a maximum of 48 hours per year in Minneapolis. Last topic, I see I'm running short of time, so I'm going to cover this really quick. There was a Supreme Court decision that came down in June of this year. This was a significant issue on a national front. I don't think it was as significant an issue in Minnesota, and that was whether or not Title VII of the Civil Rights Act prohibited employment discrimination against individuals as a result of being gay or transgender. And the reason why I say that it wasn't as significant of an issue in Minnesota is because we have a state law that protects individuals based upon their sexual orientation. And so the issue was whether or not federal law protected individuals based upon their sexual orientation. And in a nutshell, the US Supreme Court essentially found that an employer violates Title VII, which makes it unlawful to discriminate against an individual because of the individual's sex by taking an adverse action against an individual because of their sexual orientation. And so there, not only do you have protections under Minnesota law, but there is also protection under federal law as well from being discriminated against as a result of your sexual orientation. That's a lot of information in a very short period of time. I don't know if we have time for any questions. Certainly will make myself available for questions.
I don't see any questions. There were no questions that were typed into the chat. So maybe you answered everything that they needed to know.
Very good.
Will you make your slides available to me so I can share them with the attendees?
Absolutely. I will send you my slides to you, Chris. And then also, as I certainly tell PIM members, if you've participated in this webinar and you're more comfortable shooting me an email or giving me a call, I'm happy to answer your question as a courtesy as a result of attending today's webinar. So feel free to reach out to me if you do have questions concerning the information that I presented today. Otherwise, thank you very much for your time in attendance today.
Yeah, terrific, Tom. Thank you so much. Yes, Tom has been very helpful for PIM and members that ask me questions, and then I pass them along to you. So if you do have questions about today's webinar, feel free, because he is very helpful. And thank you, Tom, for presenting. We are now going into a lunch break, and our lunch break will be on our own or your own. So we would love to have you back here at 1:05 and go check those emails, eat some yummy food, and we'll see you back at 1:05. Thanks.
Thanks.